So skip 2 slides. So today, this is, if you were here last month, you'll know that this is the second in a 2-parter about adjudication. So last month we looked at preparing for adjudication. This month we're looking at how adjudication works. There's going to be a little bit of crossover, so hopefully not too much for people who were here last month, but you know, enough for those who weren't to understand what we're looking at today. So the key things that we looked at last month were the prerequisites to adjudicating. We're going to touch on those again today. And also preparing the documents. So we're going to touch on that again also. But in terms of how it works, we're going to be looking at the second bullet point down, pleadings, which is basically the submissions submitted by both parties through the process. We're looking at the adjudicator and how the adjudicator is appointed within the process. The decision, kind of what it looks like when it's submitted, what it says, etc. The cost position, so both the adjudicator's costs and fees, because the adjudicator's just doing their job, so they need to be paid, and also the costs that each party might incur if they're using lawyers or claims consultants. And finally, we'll look at what happens at the end of an adjudication, either if the sum awarded in the adjudicator's decision isn't paid, so that's enforcement, or if one or both of the parties are unhappy with the decision, what redress do they have? So if we can move to the next slide, please, Jen. So the prerequisites to adjudication and why we have adjudication in construction. Well, we have it by virtue of an Act of Parliament, the Housing Grants, Construction and Regeneration Act 1996. Bit of a mouthful, but it's the construction bit in the middle that we're interested in. And basically, the Act of Parliament introduced in England, and there's a similar related act relating to Scotland and also one for Northern Ireland, the right to adjudicate, to resolve a dispute in regard to construction projects. So this is unique and special to the construction industry. There is no other industry that has this right under an Act of Parliament. And historically, it was deemed necessary by the government of the time because of the problems with the supply chain, problems in getting paid, and insolvencies that were caused to businesses, not because they were badly run or they weren't good businesses or they didn't have lots of work, but because they had cash flow blockages. And typically that might be because usually you can't really start court proceedings until the project's finished. And when you do start court proceedings, typically it will take 12 to 18 months from starting the proceedings to the end of the trial. So you can appreciate that, you know, if a claiming business has been held out of money that should have been paid, and during that, then it has 12 months to wait to get to trial, or 18 months, and is also paying legal fees, you know, as the matter progresses. You can see how that could cause serious cash flow problems to a construction business. So adjudication was introduced as a way of having a temporary solution. It was supposed to be rough and ready, albeit it's not really worked out like that, but it is arguably a temporary solution, albeit again, it's not really worked out like that because the parties tend to accept the decision of the adjudicator and don't take the matter further, i.e. to court afterwards, albeit that the parties are entitled to do that if they're unhappy with the award. So it's not quite worked out as was initially thought, but there are also some prerequisites to being able to adjudicate. It's not simply a case of saying, oh, well, I'm a construction company and therefore I can adjudicate. So the Act specifically says that a party to a construction contract has the right to refer a dispute. So they're two different things. A is one thing, dispute is another, arising under a construction contract to adjudication. So the construction contract first, not all construction work comes within the definition within the Act of a construction contract. So, for example, building a house for the people who are going to own and occupy it, you can't adjudicate that, and that's to protect consumers, individuals building houses for themselves. It doesn't apply where a construction company is building for the house builder companies. Also, that means that you can adjudicate a dispute against the house builder companies, just to be clear. Also, you cannot adjudicate certain process works. Processes with regard to construction for the food industry, pharmaceutical industry, sewage, certain sewage works and water works, oil and gas disputes. So there are a whole raft of sort of process type works that can't be adjudicated because they are specifically excluded from this Act. And the logic there was that those industries lobbied the government when the Act was being brought in and negotiated in Parliament back in the 1990s, and basically assured the government at the time that those industries didn't have the problems that the construction industry itself had, so they didn't need to be included within the Act. So we sort of, there's a little bit of logic to individuals building their dream home not being included in adjudication. There's not so much logic for those process and other industries, so you just need to watch out for that point. So that's construction contract. The 2 points about a dispute. So A is one dispute. You can't refer multiple disputes at one time, but what you can refer is one dispute at a time. Also, a single dispute is often quite widely defined. So if it's in regard to time and money for variations, but they're all included in one application for payment and not certified, then typically everything disputed within that single application for payment, whether it's extension of time, loss and expense, extra money for variation, additional work, that can all be claimed within an adjudication, even though they're different types of claims. And we need to have a dispute as well, which sounds as if it could be quite simple, but there's a lot of case law on it. Basically, the disputes, this is the second bullet point, must have crystallised. So usually it's pretty easy to see whether a dispute's crystallised. So the example of an interim payment application, once either the final date for payment has gone by and payment hasn't been made, it's clear there's a dispute. It's probably less clear about crystallisation if it's a kind of wider claim. An extension of time claim is submitted. Again, that time the dispute will have crystallised if the claim is either rejected by the party authorised to reject it. So that could be the project manager, could be the client / employer, or if no response is received, it may be that it's crystallised once the timescales have expired. Now, in some instances, then a dispute might or might not have crystallised but there may be no clear timescales as to when the other party has to respond and either accept or reject the claim. And in that case, we're left with being reasonable. So, you know, ideally you would always, you know, submit the claim and then later send a chaser to give a further, I don't know, 7 days to respond, something like that, to try and make sure the claim has been properly crystallised. So next slide, please. So in terms of what the Act requires, so we covered this slide last month. So I just wanted to say this, that the Act sort of sets out a framework and states that the contracts that we enter into in applicable construction projects have to contain this information. So it's slightly unusual because typically if you have an Act of Parliament, what you will have is your contract, which makes various arrangements between the parties, but usually the Act of Parliament makes various statements as between, you know, the obligations between the parties. And how it's dealt with is that whatever is in the Act usually cannot be superseded or changed via the contract. So basically the Act takes priority. In this case, it's done slightly differently, but the impact is effectively the same. So what the Act says is that our construction contracts have to contain certain specific information around adjudication. And what it goes on to say is if that specific information isn't included in the contract, so for example, the sub-bullet points, the third one, which probably most people will know, is that adjudication is a 28-day process. In theory, that's got to be included into the contract in accordance with the Act. The Act requires that. If it isn't included, so if there's nothing is stated about it, or for example, the contract said it's, you know, it's not 28 days, it's 52 days, then neither of those situations are compliant with the Act. So in default, you go to what's called the Scheme for Construction Contracts, which basically is appended, attached to the Act of Parliament, the Housing Grants Construction Regeneration Act. And it provides for the 28-day time limit. So that's how it works. So what the Act requires the contract to contain is firstly that either party can give notice of intention to start or refer a dispute to adjudication at any time. Second sub-bullet point, contract has to provide a timetable to secure the appointment of the adjudicator and the referral, this kind of starting of the adjudication within 7 days of that notice in the first sub-bullet point. Third bullet point, require the adjudicator to reach a decision within 28 days of that referral, which is the starting point. And the next bullet point allows the party, the referring party, or the party who starts the adjudication, and the adjudicator between them to agree an extra 14 days for the decision on top of the 28 days. So taking it to 42 days. So the responding party, the defending party, has no say in that. Also, so this is the fifth bullet point, contracts got to require the adjudicator to act impartially, as you'd expect, but of course it's very, very important. And finally, allow the adjudicator to take the initiative in ascertaining the facts and the law. So what does that mean? Well, typically, it could mean that the adjudicator calls a meeting, albeit that that's quite rare. The adjudicator may issue a list of questions to both parties to consider and respond to in writing. The The adjudicator might, in some instances, want to visit the site, particularly if work is still ongoing and it's, it would be helpful to visit the site, sometimes for reason, delay is part of the claim and it's, delay has been caused because of the specific geography of the site, something like that. The adjudicator may wish to see it. And the adjudicator can also get third parties involved. So if the adjudicator is a quantity surveyor, for example, in some circumstances they might want to get a lawyer to assist with legal issues, a programmer, etc. Albeit that that's relatively rare. Next slide, please. So this slide just reinforces what I've already said, that if those items are, or if any of them are missing from the construction contract or contradict what the requirements are, then effectively we strike through them and you use the scheme for construction contracts. Now, we shouldn't have that problem with contracts like JCT and NEC. NEC in particular at W2 deals with all those items. JCT covers it as well. So what you need to look out for when you're reviewing these contracts is to check that those requirements haven't been amended in any schedule of amendments or Z clauses, because they wouldn't be valid. You also need to make take extra care with bespoke contracts to make sure that those items are covered. Next slide, please. Okay, so next to the pleadings. So last month I talked a little bit about the general document. So the pleadings are the various submissions made by each party, and it's a fundamental point of law that if one party makes a claim, firstly, they've got the burden of proving their claim, but in regard to that claim, the other party should always get the right to respond. That's all about natural justice and fairness and considering both sides of the argument. So the pleadings are basically the submissions made by each party, and there are a number of them in that 28-day adjudication process. So the first one, and actually the first one is the notice of adjudication, but as we saw previously, that's outside of the 28-day process. So this is the first stage of the adjudication, but technically the adjudication hasn't started until the referral, which is the second stage, is issued. So the notice of adjudication is supposed to be a brief document. It's served, if you think about it chronologically, it's served by the party starting or wishing to start the adjudication upon the other party. It's not served upon the adjudicator because we have no adjudicator nominated or appointed at this stage. So party wanting to start the adjudication issues the notice to the other party to the contract. The middle bullet point sets out what the notice contains. It's a brief document. Usually it should be maybe 3-4 pages max. So it sets out the nature and brief description of the dispute. So in non-payment or under certification of an interim payment application, you just say, that's what the dispute is. Submitted the interim payment application on such a date for £500,000 on whatever date it was certified at 200,000. As the claiming party, we dispute that that's the correct figure. It should have been £500,000, so we want to be paid 300,000. So that's the sort of nature and brief description. Details of where and when the dispute arose. This is important because, of course, we're only adjudicating by virtue of the fact that the Act of Parliament applies. So it doesn't apply to any projects outside of this country. So construction work in other countries, in Europe, they kind of have they seem to have similar mechanisms to adjudication, but it's not under the Housing Grants Act. So we need to understand where the project is, because also if Scottish law applies, for example, the Scottish rules in adjudication apply, ditto for Northern Ireland. Third sub-bullet point, we also have the nature of the redress sought. So that sounds a bit technical, but also it's basically what remedy do we want? So in this instance, we want the £300,000 paying. We probably also want some interest because we're saying it should have been paid much earlier. We probably also want the adjudicator to determine that the other party should pay the adjudicator's fees, and we might, and we'll come back to this later, want to invite the adjudicator to make an award in our favour that the other party pay our legal fees, although just be careful about that. As I say, we'll come back to that. So that's the redress sought, or the remedy. And also we need the names and addresses of the parties to the contract. Now, this document, whilst it's short, it's brief, etc., it is pretty critical to the dispute, because it sets the parameters or the ambit of the adjudication, which is relevant to the adjudicator's jurisdiction. If the claim is for £300,000 for interim payment application 18, and that's what this notice says, we can't then submit a referral that claims £400,000 and refers to interim payment application 19, for example, even if 19 substantially covers all the items in interim payment application 18, but with a few extra. So that's what we mean by jurisdiction. Next slide, please. Okay, so continuing with the pleadings documents. So the referral, this is issued by the claiming party. We know it's got to be issued within 7 days of that notice that we've just been looking at. It's got to be issued to the adjudicator, so we have to have appointed our adjudicator by this point. We'll come on to that later. When it's served on the adjudicator, it also has to be copied at the same time to the other party. So basically, adjudicator and other party get the document together. Usually nowadays it's done by email, and usually adjudicator and the responding party, the defending party, are happy to receive it by email. So that's the process. What about the referral itself? Well, the referral is a bundle of documents, and we discussed this last month. I kind of think of it as a pyramid. At the top of the pyramid, we have what will be called the referral document, usually prepared by the lawyers. It'll have various sections, but it basically is that high-level document that deals with the other documents in the pyramid. Come back to that. So that's at the top of the pyramid. Next down, we have witness statements from the project team explaining what was on site, you know, why we got behind programme to justify our extension of time, you know, why you know, the work, why we consider the work is extra work, it wasn't in the scope, all those things, referring to the project documentation, which I'll come back to. We also might have expert reports, so that could be quantity survey report on quantification of the claim, might be a delay stroke programming report supporting the EOT claim. It might be a more technical report from an architect and engineer if there are allegations of defects. So that's in that sort of middle band in the pyramid. And then at the bottom, we have the, you know, the substantial amount of documents, which is basically the project documentation. So that can be all sorts of documentation that we will append to our referral to support our claims. So it could be emails, email conversations between the parties. It can be instructions, notices of compensation events, notices of variation, agreements as to certain things, minutes of meeting. There may be invoices in there to support quantum, timesheets to support quantum also. So all sorts of documentation at the bottom of that pyramid. What you need to bear in mind is that, that's a chunky amount of documentation. So my rule is that if it's not specifically referred to either in that referral or any of the witness statements or expert reports, then query whether you really need it, and also query whether the adjudicator will actually read it unless it's expressly referred to. So bear in mind that kind of pyramid of documents, because this is what we see throughout the process. And this is the first stage. The referral is the first stage. So in terms of the referral and what it contains, there'll be a general introduction. It will typically repeat most of the information that was in the notice, because particularly our remedy, our redress sort, has to mirror what was in the adjudication, because we know that you can't claim any extra, or you can't make a different basis of claim. But the referral will contain more details. So it will contain legal argument, details as to the contract process to show that, we've followed that contract process and we're entitled to be paid that extra 300,000 in that interim payment application 18 or whatever it is. And the witness statements and the expert reports will back all of that up. And then, of course, as we've seen, you'll have all the project documentation, hopefully, to support the claim as well. So next slide, please. So we've been the claiming party, the referring party. So now if we change identity and we become the defending party, or the responding party as it's called in adjudication. So what do you do when you receive the referral? Well, remember, of course, for probably about 7 days, a maximum of 7 days, possibly a bit shorter period, you've had the notice of adjudication. So hopefully you've been really preparing quickly and getting, trying to work out what the claim is about and getting a bit of a head start. You'll then get the referral, which gives you all the details. So hopefully you kind of well into the detail of your response, which is the document that you need to prepare to respond. However, what your lawyers or your claims consultant will be doing the day they receive the referral will be looking through to make sure to see if there are any jurisdiction challenges. So they're those challenges that go to the ambit or the remit of the adjudicator that we've looked at. Possibly there's more than one dispute, the dispute hasn't crystallised, the remedy sought in the notice of adjudication isn't mirrored in the referral. Any one of those items, the responding party solicitors will be looking for those, and probably within about 24 hours of receiving the referral, we'll be making a written submission to the adjudicator to say, dear adjudicator, please note, in our view, you can't proceed with this adjudication. You don't have jurisdiction. It raises 2 disputes. That's in breach of the rules. You can only have 1 dispute at a time. So please resign. The adjudicator, upon receipt of such a challenge, will invite the referring party to respond and put their case. Again, probably only get 24 hours max to do that, and then the adjudicator will make a decision on that point. If the adjudicator decides they can proceed, everything's okay, that's fine. Come back to that point later. If the adjudicator agrees with the defending party, yeah, there are 3 disputes here, I can't deal with this, then the adjudication comes to an end. But what it means in many cases, and particularly the 3 disputes argument, is just that the referring party can go away, strip out the 2 extra disputes and remedy it, and start the process again, but just referring 1 dispute. Now it means they've got to go away, do a bit of work to do that, and then start the process again with a new notice and then a new referral. So you might say, well, what's the point of the defending party doing all that? Well, the point is that if by doing so, it means that you don't waive that position. So if you didn't make the challenge, you would have been deemed to have waived it in most instances. But also critically, it can give you a week to 14 days extra preparation time, because bear in mind, you've now got the referral, so you understand, you know pretty much what the disputes are about. So it just gives you critical extra time in this system, which only allows the responding party very short periods of time. So next slide, please. So these are some of the challenges that you can make, which we've already covered. So the next slide, please. So assuming that the adjudicator has said, well, either assuming there are no jurisdiction challenges, or that the adjudicators considered them and said, no, I don't agree, we need to proceed. The adjudicator very quickly, so again, probably 24 to 48 hours from the referral being served, will issue directions. Sometimes they'll just be very standard directions. So, 7 days for the responding party to respond and produce a response document, which again will be that similar pyramid. A response document, witness statements and expert reports, and then any supporting documents. Usually the supporting documents will be far less in number than the referral, because the referral should contain most of the project documents. There may be extras that the defending responding party wishes to rely upon, in which case they need to be included. Often, if the adjudicator issues fairly standard directions, what you might find is that the responding party, or both parties, go back to the adjudicator and say, actually, we need more time. So, 7 days given for the response. Typically, the responding party will try and argue to get a little bit longer. And it's a little bit of a negotiation between the 2 parties and the adjudicator. But typically, as far as the response is concerned, an adjudicator will give around 7 to 21 days from the date of the referral in which the responding party has to submit its response. It depends on the issues raised as to whether responding party gets 7 or 21 days or something in the middle. And clearly, if they're going to get 21 days, that's eaten up 3 weeks of our 28-day process. So typically in that instance, there's extra 14 days that can be agreed between the referring party and the adjudicator will be used. So we've already seen that the same pyramid applies in terms of the response and all the documents. So that's served within the timescales, hopefully, on the adjudicator and the other party. Always, when you serve something on the adjudicator, you've always got to serve your opponent, and that applies to both parties. And similarly, if the adjudicator communicates to one party, they've always got to copy the other party in. And if the adjudicator asks questions of one party, then they've got to allow the other party to deal with those questions as well. And it's all about transparency and fairness. The key on all of these pleadings is to try and keep things as simple and concise as possible. And where you're referring to your backup documentation, that documentation at the bottom of your pyramid, or if you're cross-referencing to the other party's backup documentation, make sure you clearly cross-refer to it. I like to use quite a lot of quotes in my submissions and also witness statements and expert reports, because I think if you're quoting project documentation, it then means that the adjudicator is not having to look for each piece of project documentation to check what was said, but also if they do want to check it, it's easier to find if it's being quoted or the relevant part has been quoted, rather than trying to, hunt for something which has been summarised by a party in a submission or in a statement. So the response is submitted, and typically there may be another round of submissions. So the bottom bullet point deals with the reply, which is the submission that the referring party, the claiming party, makes once it's had chance to consider the response. So in this respect, the pyramid documents are getting shorter and less bulky on each occasion, because there's less to say, because it's the second submission as far as the reply is concerned. The rejoinder is the document that follows that. So it's the defending party or the responding party who would submit that. And then the surrejoinder would be submitted by the party who started the adjudication. So again, as each submission goes along, the pyramid gets smaller effectively. So the submission will get shorter, the witness statements will get shorter, and the project documents will become fewer, hopefully. And also the timescales for submitting them will become shorter and shorter. So typically, if you're given 10 days for the response, you might get for the reply 7 days, and the rejoinder 4 days, and maybe a day, a couple of days for a surrejoinder if that's needed. Now, these documents are submitted to cover issues that either need clarification from previous submissions that you've made, or, for example, if the response contained wholly new arguments that hadn't been made by the defending party in correspondence, earlier, then the reply would be allowed to cover those new points, and the same with regard to the rejoinder and the surrejoinder. So next slide, please. So just looking at how we select the adjudicator. So either the contract that is signed up to between the parties will contain either the name of an adjudicator, or sometimes several, one of which can be picked, or sometimes in order of priority. So a named adjudicator, I'm not particularly in favour of that, particularly if you're likely to be the responding party. So if you're a subcontractor in a subcontract, or a contractor in a main contract, because you're likely to be the party adjudicating because you consider that you've been underpaid. So if the adjudicators named have been, as is typically the case, have been named by the paying party, then you might not feel comfortable that they're going to be wholly independent and neutral. So the other way of doing it, if the contract doesn't nominate state individuals, named individuals, is nomination through one of our construction trade bodies. So for NEC, usually we have ICE as the nominating body. But you can pick when you negotiate the contract, RACS, CIOB, there are a variety. And it's really simple. If you go onto any of their websites, I think ICE's, there's a tab that's dispute resolution. There's another tab that's adjudication, and then there's one that's appointing an adjudicator. And there are a couple of different ones. One's for a specific project, but then the other it's just a form to fill in for a standard adjudication, and it's the kind of information you'd expect to be provided. You know, the names of the parties, what type of contract, what's the dispute about, what's the value, you know, any particular discipline of adjudicator. So you fill in the form, you send it usually by email to whichever one, and then pretty much as soon as you've issued it, particularly with ICE, you get an email back to say, we've got your email, we've got your request to nominate, we will let you know. If it looks like they're taking a little bit of time, I would usually chase them, because of course, the final bullet point here reminds us that from that notice of adjudication, you've only got 7 days to get the adjudicator nominated. So you can't really afford for the nominating body to sit on this for too long. And I must say that they're usually really good. You know, within 1 or 2 days, they've nominated someone from their panel. So that's the key point. You also need to check how you select the adjudicator. So it's quite clear in NEC, if you're going via a nominating body, you've got to get your notice of adjudication served on the other party first. And only once it's been properly served can you then submit your form to ICE or whoever requesting that they nominate an adjudicator. You've got to be really careful about that process. And again, if no adjudicator's nominated within 7 days of the service of the notice, then in the same way as if the referral isn't served within 7 days, you've got to start again with the whole process. So you just need to be careful of that, because you don't want to have to do that, because as we've seen, it gives the responding party that tactical advantage of, you know, seeing that you're about to start an adjudication, and you know, means that they can start to prepare their response earlier than would normally be the case. Next slide, please. So this sets out the powers of the adjudicator, which we've pretty much covered. Next slide, please. So the decision of the adjudicator, well, first bullet point, we know got to reach a decision within 28 days of the receipt of the referral, but it can be extended to 42 days if the referring party and the adjudicator agree, or it can be extended beyond the 42 days, providing both parties agree and the adjudicator agrees. And, you know, it is often the case that it goes beyond that. For your typical adjudication, though, it shouldn't go much beyond 42 days. You know, we're trying to strike a balance here between everybody making all those pleadings, all those submissions that we've just seen, but also, you know, the idea is still, you know, this is a quick remedy. The decision will deal with the remedy that has been sought by the party who started the adjudication. You know, in our case, is that 300,000 due? Is it less? Is it zero? It'll also deal with payment of the adjudicator's costs and expenses. So, you know, if the award is yes, I mean, it would be, to be fair, really rare, but if the adjudicator was to say yes, referring party is entitled to the full 300,000, then typically the other party, the losing party, would have to pay all of the adjudicator's costs and expenses. And really, if the adjudicator awards the referring party, 70 to 80% of the claim, then typically the adjudicator will say that the losing party has to pay all of its fees and expenses. Anything less than 70%, then the adjudicator might share how their fees and expenses are to be paid. So, I've seen awards where the referring party hasn't got all of what they've claimed, and therefore they've had to pay small amount, 10% of the adjudicator's fees, and the losing party 90%. Really important is the final point. So the adjudicator's decision is binding on the parties until the dispute's finally determined by court proceedings or arbitration. So effectively, that means that we've got to observe the award. So if it awards payment, the payment's got to be made, subject to jurisdiction points, which we'll come on to. But once that payment has been made, the party who has made payment, who's unhappy with the award, and to be fair, it could be the other party, because if on our £300,000 claim we're only awarded 50,000, we might be unhappy. So the 50,000 has to be paid, and then either party or both parties might decide they want to take it further, and in that case they would be starting court proceedings, or if the contract contained an arbitration clause, arbitration proceedings. Court and arbitration are very similar. They're alternatives. Typically, take 12 to 18 months to run through that whole process. So they're quite expensive in terms of legal cost. So typically, the parties, even if they're unhappy with the results of the adjudicator's award, typically they will accept that as between them. You don't have to take matters on to court or arbitration, but you can. And if you do, what you will find, and you might think this is strange, but what you will find is that usually very little reference is made to the adjudication. It's almost parked, and the matter, the matter is heard, from scratch. The only time when it might be relevant that there's been an adjudication might be if, say, a party gives a witness statement in court proceedings which contradicts what they say or said in a witness statement in the adjudication. But other than that, the adjudication is pretty much sidelined through the court and the arbitration proceedings. And the other thing that's available to the parties to supersede the adjudicator's award is if the parties subsequently reach an agreement which alters the award, which could happen if, for example, in our 50,000 example, obviously the referring party is going to be really unhappy about that, but also the defending party might be thinking, that was a poor decision. We'd expected maybe to pay 100,000, but 50 looks really, looks too light. And there's a risk the other party might go to court, which would take up 12 months of our time. We'd have to pay all the costs. We'd end up paying 100,000, we think, maybe more. So in that case, both parties might be able to reach an agreement that changes the decision from the adjudicator's decision. Next slide, please. We've already seen, so legal costs and adjudicator's costs, we've already seen that the adjudicator's entitled to cover which party pays their costs in their award, which makes sense because it's their job, they need to be paid. So that's the mechanism for for getting paid. It's really difficult to challenge adjudicators' costs. Also, generally speaking, the parties will pay their own legal costs. So I mentioned that in the referral, the referring party might want in the redress or the remedy sought to claim their costs. There's a strict procedure to be followed to include that, which means that you can only ask the adjudicator to determine that one or the other party pays the other's legal costs. So the loser, effectively the loser pays the winner's legal costs. And if the parties agree once the adjudication has been commenced that scenario is to apply, it is really rare that happens. The general rule is that the parties bear their own legal costs. And that happens in 99.9% of cases. What you can't have is a contract that either predetermines who pays the costs or requires, so you couldn't have a clause that deals with legal costs at all as between the parties. So you couldn't have a clause to say, you know, whoever starts the adjudication pays the other party's legal costs. And also you couldn't have a clause that says whoever loses the adjudication pays the other party's legal costs. Any kind of clause like that would be invalid. So that's legal costs. We can move on to the next slide, please. So we're looking at enforcement, and the basic position, as we've already seen, is that the adjudicator's award has to be complied with, and if the party who's unhappy, or both parties, if they're both unhappy, want to take the matter further, they go to court or arbitration. If the paying party or the party who should have paid wants to take the matter to court, then they can't do so until they've made payment. Usually the adjudicator will order payment to be made within 7 days. So it's a pretty, you know, it's required to be made pretty quickly, which stands to reason because it's supposed to be a quick process. So what happens if the party who was ordered to make payment to the other party fails to make payment? Do you have to go to court for that whole 12-month process? Well, no. What you can do is go to court for enforcement to enforce the adjudicator's award. So let's be clear, this is different to not being happy with the adjudicator's award, so starting court proceedings to get a different decision. This is the party who hasn't been paid but should have been paid, starting proceedings to say to the court, look, we've got this adjudicator's award. It says we're entitled to £250,000. It hasn't been paid. Please help us, court. Please make an order. Please make a court order for that money to be paid. And why you need that is because a court order is what is needed to start financial enforcement proceedings, whether that's kind of getting the bailiff or the sheriff to uplift goods, starting winding up proceedings. So all these processes, you typically need some form of court order. So you'd be pleased to hear, if you're the referring party and you haven't been paid, these applications to enforce the award are dealt with by the court really quickly. It's a policy decision because it stands to reason that you know, it shouldn't take a long time because it's supposed to be a quick process to preserve cash flow. So typically, this is the middle bullet point, if you start these enforcement proceedings, you should get a hearing date within about 14 days of starting the proceedings. But bear in mind, you'll have had your decision, you'll have had your adjudication award, which will usually say 7 days to pay. Those 7 days will have gone by. You've probably sent a reminder. You've then had to prepare the court papers and start the court proceedings. So you're probably, 3 to 4 weeks on, and then you'll get a hearing, hopefully within about 14 days. Usually the court does enforce the awards. If we can move on to the next slide, please. So what's enforcement about? Well, it's all these jurisdiction challenges, so about the ambit of the adjudication. So this 1 dispute or 3 disputes, the notice being different to the referral, all of those things. But also, and this is the 4th sub-bullet point, about impartiality or bias. So, for example, adjudicator emailing one party but not the other, adjudicator coming to a decision without giving both parties the opportunity to consider a specific point. So, basically it's not following the rules of natural justice and giving, each party a fair say. So, they're all grounds for an adjudicator the court not enforcing the adjudication award. So it kind of means that, the circumstance where we saw at the start, where the referring party challenges the adjudicator's decision, where the adjudicator says, actually, I'm confident that I have jurisdiction, the referring party needs to be confident also, and needs to kind of be quite cautious, because if the adjudicator is wrong, the parties go through the whole of the adjudication, incur all those costs, get that decision, and then the court potentially refuses to enforce it. So effectively, it's just been a waste of time and money. So, both parties just need to be really careful about these enforcement issues, particularly the jurisdictional issues, but also the impartiality and the bias as they go along. Also, insolvency, whilst you will get an adjudicator's decision if the if the claiming party is insolvent, typically the claiming party won't be able to enforce it unless there are special circumstances. So potentially you could enforce a final account claim based on the fact that that was final and conclusive on the parties, but there are kind of quite complicated rules as to a referring party in insolvency, whether the adjudication awards are enforceable, which is, quite a discrete area. So that's next slide, please. Yeah, so this just covers the point that aside from enforcement, if you're not happy with the adjudicator's award, you can go to court and have the matter dealt with as if it hadn't been adjudicated, providing obviously that the adjudication decision, the adjudication award, has been complied with by the party who had to make payment under the award. Next slide, please. Yeah, so that's everything for today. Happy to answer any questions. Also, I think my email was on about that second slide, if you've got any questions that you think about in the next few days. Any questions?
There is one question that came in about midway, and people seem to agree that it was a good question. So if a party objects to an adjudicator, is there a remedy to change this? This often happens, yet procedures still continue to completion, leaving both parties frustrated.
Yeah. If neither party, like the adjudicator who's been nominated, then you could agree to get a new one. The difficulty from the referring party's perspective there is that you've got to weigh that up with the delay that will ensue, and the tactical advantage that gives the responding party. But yes, I mean, I've had a situation where I was keen to get a different adjudicator because I just felt that the one that we were dealing with was struggling. So yes, that does happen. I would say it's quite rare that both parties want to dispense with an adjudicator. Usually it's just one. So typically, if you've got named adjudicators in the contract, you can't, you are basically stuck with them unless both parties agree in advance that those adjudicators shouldn't be used. But that requires the referring party to approach the other party before they set off with the notice of adjudication to consult. So, I had that scenario once when, for various reasons, we felt that the adjudicator that was named in the contract was conflicted because they were involved in the project through various means, and both of the parties agreed that it was inappropriate because they wouldn't have been independent. So parties agreed to dispense with the named adjudicator, and we got a nominating body to appoint one. If there's anybody in the list when, as a referring party, you are asking the nominating body to appoint, you can ask for them to be discounted, but you just need to be careful about who you ask to be discounted and why. So, what it's probably better to do is to say, well, this is a quantum dispute, so a quantity surveyor would be the best person. It's a very technical engineering dispute, so an engineering adjudicator is best. What you can't do with the nominating bodies is say, oh, well, we'd like Fred or Frida blogs because we really like them, because, then you really risk an argument that they're not independent. But what you need to bear in mind is that adjudicators are professional people. They're usually lawyers or construction professionals. They all have reputations to uphold, and once they are appointed, they need to consider whether they have a conflict, and the parties do as well. So if there is a conflict, then I would expect the adjudicator to say, look, I can't act on this because I've been involved. So typically, it's difficult to object to an adjudicator. They've all passed certain tests and exams, so in theory, they all should be good for dealing with a dispute, but I do appreciate sometimes quality is a bit mixed.
Perfect. And we've just got another question coming, Sarah, if that's okay.
Yeah.
So if the referring party becomes insolvent because of no payment from non-payment from the awarded adjudication, would that be a special condition for the court to enforce payment to the insolvent party?
Yeah. I mean, none of these are set in stone, but that is one of the technical issues where, if the insolvency has been caused by the failure to pay, which is the subject of the adjudication, then the chances are that adjudication would be upheld. I mean, it's slightly academic because typically, if your business is insolvent, the insolvency practitioners will deal with whether you adjudicate or not. If you're defending an adjudication brought by an insolvent company, then I suspect you'll get your lawyers involved. And there are various grounds where the adjudication can proceed and be enforced, and some grounds where it won't be enforced.
Perfect. Thanks again, Sarah, and thank you for answering the questions. That's it in terms of questions, but like Sarah said, if anybody does have any others, then you do have Sarah's email address, and that'll be on the slides that I've sent out to you afterwards. Now, just in case you guys aren't aware, the next programme of construction law seminars and webinars have been put up on our CECA Yorkshire and Humber website under the events. So if you do want to have a look at the programme beginning in September, then please feel free. There is going to be a seminar for every webinar, and we would really encourage you to, where you can, attend face-to-face, because there's that chance for networking and also to speak with Sarah face-to-face, which a lot of our members have found beneficial. But that's everything from me today. So I'll email out the slides. As I say, if you want CPD certificates, pop me an email over, and the recording of this will be uploaded to our YouTube channel afterwards. I can see that another question has come in, but I am conscious of time. So if it's okay, Sarah, I'll email you that. And then once you email me the responses, I'll share those with all the attendees. Right, perfect. Thanks so much, Sarah, and thanks everyone for attending.